We're Dr. Shield, and we do insurance differently than most companies. Things like simplifying details so it's easy to understand what makes us Malaysia's most innovative indemnity provider. As a Dr. Shield client, you'll enjoy comprehensive coverage with fewer exclusions. With some insurers, you'll only find out what's not covered when you make a claim. Our policy details are online and easy for everyone to understand. Competitive premiums that don't keep increasing. Many insurers increase their premiums across the board to compensate for losses. Dr. Shield limits the number of doctors insured from high-risk categories, so our premiums start fair and stay fair. Prompt dispute resolutions. We're pro-mediation because settlement and negotiation, instead of endless litigation, is better for everyone. Career and reputation protection. Typically, litigation can drain a doctor financially and emotionally. We limit the damage by both, so our clients emerge good names intact. And peace of mind, because a happy doctor is a good doctor. Our different approach to creating policies means we put you first, before us, so you can enjoy your career and sleep like a baby, even if you've just delivered one. Dr. Shield, insurance with a difference.
Welcome, everyone, and it's time for another medical legal webinar brought to you by Dr. Shield, Chubb and Dobbs. So today's topic is on, is there an expert in the house? And presenting this is Puan Maitzura binti Muhammad of Messrs. Azim, Tunku Farid and Wong. And it'll be a short and sweet presentation, so please stay tuned. Before I stream the presentation, I just want to go through some housekeeping slides. Now, as usual, we'd like you to join us on Slido for the Q&A, which will be after the presentation is over. And that's when Puan Maitzura will join us live. So the code for the Slido event is 3068108, which you can enter if you have downloaded the Slido app on your mobile or you're on slido.com on your browser. If you scan this QR code with your normal camera scanner, it will take you to the same location. Please don't forget to subscribe to our channel. It will help you stay informed of our upcoming webinars. Now, CPD points are available for today's webinar. The dentist would have a pre-registration form already. And for the medical doctors, an attendance link will be displayed at the end of the talk. All right. So without further ado, I'm going to start the presentation.
Good evening to all. I would like to express my thanks to all involved for inviting me to present today's webinar. I'm truly honored to be given another opportunity to be involved in such a program. I would like to state that the views shared in this webinar are my personal views and do not in any way reflect the views of any organization or association which I may be involved with. The title of my presentation tonight is there an expert in the house? Let me first set the scene. A medical practitioner is sued in court. The allegation against the medical practitioner is that he or she was negligent in some way, either with regard to advice, diagnosis, treatment, or management. The lawyers representing the said medical practitioner need to assess whether the medical practitioner has acted according to the applicable and accepted standard of care. So the first question that arises is, what is the accepted standard of care? And the related question is, how do we establish the accepted standard of care? At this point, enter persona dramatis, named Dr. Expert from stage right. At the outset, I would like to read an extract from the judgment of the Court of Appeal of Malaysia in the case of Batu Kemas Industries Sdn Berhad versus Kerajaan Malaysia Tenaga Nasional Berhad. For those interested outside, the citation is 2015 5 MLJ 52 Court of Appeal. And this is the extract. Apart from the field of law, the court itself has no other expertise. For that reason, in cases involving technical, scientific, or medical issues which require specialized knowledge, such as forgery, intellectual property, medical negligence, and other like cases, the court frequently has to rely on the evidence of experts. As such, this is a case in which the court has no expertise. Therefore, the evidence of an expert is called upon to assist the court in arriving at a correct decision. End quote. When a medical practitioner is sued in court, the medical practitioner will, in the usual course events, seek the assistance of a colleague practicing in the same discipline to act as an expert on his behalf. A short explanation as to the role of an expert. In general, a witness is only allowed to testify as to things that he has experienced with his own senses. So, what he saw, what he heard, what he felt, etc. A witness is usually termed as a witness of fact. An expert, on the other hand, has a special place in judicial proceedings. He is allowed to testify as to his opinion. Thus, to distinguish an expert from a witness of fact, an expert is commonly referred to as a witness of opinion. In recognition of the unique position of an expert position in legal proceedings, there are various legal provisions which govern the testimony of an expert. I will mention a few principal leading legal provisions. The first, Evidence Act 1950, in particular Section 45. I read, quote, Opinion of experts, Section 45.1. When the court has to form an opinion upon a point of foreign law or of science or art, or as to the identity or genuineness of handwriting or finger impressions, the opinions upon that point of persons specifically skilled in that foreign law, science, or art, or in questions as to the identity or genuineness of handwriting or finger impressions are relevant facts. The second is Order 34 and Order 40, capital A of the Rules of Court 2012. The procedural legal provisions in the Rules of Court 2012 have set out when and how the opinion of an expert is to be presented in court. An integral theme running through these provisions is the independence and non-partisan position of an expert. These provisions also provide a procedure which may be adopted involving an exchange or discussion or discourse between experts who have been appointed by the opposing parties. This process is amusingly called hot tubbing. The third, guidelines issued by the Malaysian Medical Council, the MMC. As guidance to the medical fraternity, in particular a medical practitioner who intends to take up an assignment as an expert, the MMC has passed its own guidelines. This document can be easily found on the MMC's website. For members of the medical profession who have taken up the appointment as an expert, and also to those who are considering to do so, I wish to share with you the instructive words of Creswell J., a judge of the English High Court. In his decision in the case of the Icarian Reefer, citation 1993, 2 Lloyd's Law Reports at page 68, his lordship went on to set out his views clearly and unambiguously on the duties and responsibilities of expert witnesses as follows. This is what his lordship said, quote, The duties and responsibilities of expert witnesses in civil cases include the following. 1. Expert evidence presented to the court should be, and should be seen to be, the independent product of the expert uninfluenced as to the form or content by the exigencies of litigation. 2. An expert witness should provide independent assistance to the court by way of objective, unbiased opinion in relation to matters within his expertise. An expert witness in the High Court should never assume the role of an advocate. 3. An expert witness should state the facts or assumption upon which his opinion is based. He should not omit to consider material facts which could detract from his concluded opinion. 4. An expert witness should make it clear when a particular question or issue falls outside his expertise. 5. If an expert's opinion is not properly researched because he considers that insufficient data has been made available to him, then this must be stated with the indication that the opinion is no more than a provisional one. In cases where an expert witness who has prepared a report cannot assert that the report contained the truth, the whole truth, and nothing but the truth without some qualification, that qualification must be stated in the report. 6. If, after the exchange of reports, an expert witness changes his view on a material matter having read the other side's expert report, or for any other reason, such change of view must be communicated through legal representatives to the other side without delay and when appropriate to the court. Where expert evidence refers to photographs, plans, calculations, analysis, measurements, survey reports, or other similar documents, these must be provided to the opposite party at the same time as the exchange of report, close quotes. Although the Icarian refer is a case involving marine law, in my opinion, the words of Creswell J. apply to all legal proceedings where the testimony of an expert is required. This then leads me to the question, why is the opinion of an expert required in a case where a medical practitioner is sued? At a trial, the determiner of the outcome is the judge. On one side, you will find the patient or the family members of the patient. On the other side, you will find the medical practitioner who has been sued. In most situations, the judge is not equipped with medical qualification, training, or knowledge to determine medical-related issues. As an example, if the case before the judge were an obstetrics case, some of the medical issues may be: 1. Was the mother in labor? 2. Was the baby in distress? 3. Was there an indication for emergency lower cesarean section? 4. Was the time taken to perform the surgery within the acceptable timeline, and etc. In order for the judge to understand and then decide the medical-related issues, the patient or family members will seek the assistance of an expert. Similarly, the medical practitioner will seek the assistance of an expert. The judge will then hear the opinion of the opposing experts. If the experts do not agree with each other, or only agree on some but not all issues, then the judge will have to decide which opinion is preferred, subject to a caveat. The caveat is that the opinion of the expert, which the judge accepts, must be reasonable, responsible, and logical. This principle of law was decided by the House of Lords in the UK in the case of Bolito v. City and Hackney Health Authority. Citation 1997 4, All England 77, or 1997 3, Weekly Law Reports 1151. This principle of law has been accepted by the superior courts in Malaysia and is therefore part of the laws in Malaysia. At this juncture, I would like to read an extract of the judgment of the Federal Court of Malaysia in the case of Zulhasnima binti Hassan Basri and another versus Dr. Kupu Velumani P and others. Citation 2017 5 MLJ 438. In this case, the Federal Court of Malaysia had the occasion to consider the role of an expert, and this is what the court said. Quote, given the fact that there are genuine differences in opinion as to diagnosis and treatment, it is therefore not a matter that the court can or is equipped to resolve. It is in this context that the Bolam test makes good sense. It requires the court to accept not just the views of the medical expert simpliciter, but the views of a responsible body of men skilled in that particular discipline. It removes from the court the responsibility of resolving a dispute that it is not equipped to resolve. Close quotes. In my involvement in cases where medical practitioners have been sued, I've had the pleasure of working with various experts from different medical disciplines. Depending on the case, I would, on any given day, pretend to be a neurosurgeon, a cardiologist, an anesthetist, or an obstetrician, and so on and so forth. In my, quotes, adventures, I've had the privilege and honor of being guided by many medical practitioners and experts who, in my opinion, are marvelous teachers who are always ready to share their wealth of knowledge with me. They are, in my own words, giants in their own field, but to me, they are first and foremost great men. Single pleasure, double honor, and triple privilege to these great men. You know who you are out there, and to those who have given me such great tutelage, I have been able to appear competent in presenting a medical legal case or a defense in court. For this webinar, I would like to take the opportunity to highlight a number of pointers obtained from medical practitioners who have taken on the challenge and have acted as an expert in medical legal cases. These are some of the tips that have been shared with me. Number 1, stay in your own lane. I think this is easy enough to understand. If you're a specialist in a particular area of medicine, do not offer your views on any other area of medicine which is not your usual area of practice. I would like to also mention that the practice of medicine has become very specialized in recent times. Therefore, as an example, on one occasion, I had approached an obstetrician and he or she had advised me to consult a fetal medicine specialist. Pointer number 2, you are not a gun for hire. At all times, an expert should offer an independent view of the issues at hand. Your opinion must not be dependent on the fact that you were remunerated by the party who appointed you to render your opinion. If upon due consideration, there are issues that can be agreed upon, even if they are not beneficial to the party who have hired you, the expert should not disagree. At this point, I would like to make a comment on potential conflict. The medical fraternity is fairly small. As a medical practitioner, you will, of course, have to come to know, to differing degrees of familiarity, many of your peers at different stages of your career. For instance, another medical practitioner who was with you at the same university, a medical practitioner who did housemanship with you, a medical practitioner who was or is still your colleague. It is worth repeating that an expert must be unbiased and must be able to render his or her independent opinion based on the available material. However, there are very few situations when a medical practitioner is automatically disqualified from accepting an assignment to act as an expert. A clear example, a medical practitioner who has been sued is a family member of the intended expert. The MMC guidelines mentioned earlier have highlighted a particular aspect of conflict. In the MMC guidelines, it is expressly stated that a medical practitioner, quotes, involved in the management of the same patient as the medical practitioner who has been sued is not permitted to appear as an expert witness in such legal proceedings, close quotes. So how should an expert deal with the issues of potential conflict? If there are concerns that there may be potential conflict, the expert should be upfront and make early disclosure to the potential conflict to the party appointing or paying him, so that necessary steps can be taken to forthwith inform the opposing party and the court. Pointer number 3, mind your language. Many a times, an expert becomes invested in this dispute between the patient or family members on one side and the medical practitioner on the other side. No matter which side you are appointed as an expert should use temperate language at all times. In carrying out your duties as an expert, it is good to always remember that you must be objective and unbiased at all times. Regrettably, I have seen some reports prepared by so-called quotes independent experts where the language used therein is inflammatory and littered with exclamation points. Pointer number 4, apples and oranges. An expert is asked to evaluate the acts and omission of the medical practitioner at the time the adverse incident happened and according to the standard of care applicable in Malaysia at that time. Therefore, if the issue to be addressed is the use of, say, a particular device by a medical practitioner in the year 2020, then it is irrelevant that such a device is widely used in the UK in 2020. The issue here is whether the device was the standard of care, the use of the device was the standard of care in Malaysia in 2020. Pointer number 5, prepare, prepare, prepare. This tip is something that goes without saying. As an expert, you have to be prepared. This means 1, be familiar with the documents that have been put before the court. 2, read the opinion that you have prepared. Sometimes, a long period may have passed between the time you have prepared your opinion and the date that you are testifying in court. 3, refresh yourself with the medical literature that you are relying on. 4, brush up on the latest medical literature in case you are asked. 5, be familiar with the opinion of the opposing expert and the medical literature. I recall that in one of the cases that I was involved in, the expert commented that he felt like he was preparing for his viva at medical school. Pointer number 6, allocate time. After you prepare your opinion, your responsibility as an expert may not end there. I say may because if a trial were to take place, the lawyers representing the party who has appointed you may need you to assist them with their own preparation. Be prepared to make time for them. This is part of your responsibility as an expert. Pointer number 7, keep your cool. D-Day has come. You are not testifying at the trial. By this day, you have done your preparation and ready to do battle. But it's important to remember that you are not a gladiator fighting for the party who appointed or paid you. Your role is and always is to assist the court, and your overriding duty is to the court. Finally, remember to breathe. Be courteous always and keep your cool. As a postscript, I would like to say that in my view, these tips apply across the board, whether you have been appointed as an expert for the patient or family members, whether it's for the medical practitioner, or whether it's for the hospital who have been sued. In conclusion, I would like to share an extract from an interesting and heartwarming account by a senior medical practitioner who has shared his experience as an expert in a medical malpractice case. In his book titled Joy, Hope and Challenges, My Life Journey, the author has issued a timely reminder to his fellow medical practitioners in the following way. Quote, in conclusion, be honest with yourself before taking on the role of being an expert for or against a colleague. Honest your assessment as to culpability after a thorough examination of all the facts presented to you. Honest in your qualification and experience to give an objective and reasoned opinion on the particular case. Honest in upholding the prevalent standard of care in managing the patient. No other reason should justify you accepting to act as an expert witness other than ensuring that the truth is upheld and explained, whether you are for or against your colleague, so that your colleague will be given a fair hearing, culpability aside, close quotes. Before I end and we proceed to the question and answer session, I would like to take this opportunity to make a sincere plea to all medical practitioners out there, especially those who have joined us this evening, to make the time in their understandably busy schedule to step up and help another member of their profession. It is useful for all medical practitioners to remember that, but for the grace of God, you could have been in the same situation as the medical practitioner who has been sued. To those who have taken on the appointment of an expert, and to those who continue to do so, always discharging their duties according to the standards set out in the case of the Akira Rifa, I wish to publicly record a heartfelt thank you to each and every one of you. On the issue of availability and access to experts, I do not know of any formal structure at present in Malaysia. Perhaps it is time for existing organizations to think about how to put in place a formal and structured system for the identification of appropriate medical practitioners who are happy to help a fellow medical practitioner. Hopefully, organizations which are established with the principal objective of looking out for the interests of medical practitioners in Malaysia will take up this issue. We have now come to an end to today's topic. I sincerely hope that I have been able to shed some light and provide some legal and practical insights on my chosen topic. I wish all those participating in this webinar all the very best in their endeavors. Again, I wish to thank the organizers of this useful program for giving me the opportunity to present today's topic. Thank you.
Thank you, Puan Maizara, for the excellent presentation. And just to remind you all, before I bring Puan Maizara live on the stage, that we are now at the Q&A session. Please join us at slido.com. The code is 3068108. Okay, without further ado, I'm like to bring Puan Maizura on the stage. So, hi, welcome, Puan Maizura.
Good
Can you
evening.
hear
Thank
me?
you, Dr.
Yeah,
Aaron.
good evening.
Yes.
Yeah. So we have, I think, about 30 over live participants watching at the moment. Let's go to Slido to see if there's any question. No, but we got a whole bunch of questions in YouTube. So let's tackle the YouTube ones first, since they've appeared. Okay.
Sure.
So question one. Challenging cross-examination. What strategies do you recommend for maintaining credibility and composure when faced with aggressive cross-examination? I think this is one of the concerns and fears of doctors when you appear in court, and as an expert witness, but we don't like to face this sort of aggressive questioning during either cross-examination. What tips can you give other
Okay.
than try to maintain composure, which
Two
can be difficult?
immediate points. One, know your facts well. When you know your facts well, then you will be able to render your opinion to assist the court in the appropriate manner.
Yeah. I think the facts will always make it easier once you have them and answer in a factual manner.
Yes.
Yeah.
So, I mean, the point would be that by the time the matter goes to trial, you have already written your opinion. It would already been shared with the court and all the other lawyers acting for all the different parties. So, with your expert report and the medical literature that you have referred to in support of your expert opinion, you should be able to answer those questions. And I always remind witnesses, whether witnesses of fact or witnesses of opinion, we're all here to tell the truth. And with the telling of the truth, you will not be caught up. I sincerely believe that.
All right. And I think the next point is quite pertinent, because sometimes when we go into expert testimony, it's a bit of an art, because sometimes the things can be very technical. And do you have any ideas or tips on how we can make it uh, easier for judges, jury, or whoever to understand the concepts?
Okay, in Malaysia, trials, be they civil trials or criminal trials, are only presided over by a judge. Unlike other jurisdictions in Malaysia, both in civil and criminal matters, there is no jury. So the only arbiter of facts and law and medical opinion would be the judge. So what I would say to an expert who's about to take the stand is, imagine you are explaining whether advice, diagnosis, treatment, or management to a patient, the way you would explain to a patient would be how you would explain to the judge. You always assume that the patient is not medically trained. And if you take that approach, then I think you're not oversimplifying, neither are you being highly technical. You will be able to reach that required level of explanation.
Okay. We'll take one question in Slido. Actually, it's not quite related to expert witness specifically, but was there any dental lawsuits filed in recent years? Often we hear medical ones, but what about dental ones?
I can only speak from my own experience. The answer is yes.
Okay. I'm sure there have been. Just don't appear in the newspapers.
Well, yeah, I suppose depending whether it's reached the media or not.
Mm. Okay, this is an interesting question, which also I have some concerns. What are the ethical boundaries for the expert witness when their findings or testimony might favor one party disproportionately? Maybe, let's say, when our opinion actually do not actually align with the hiring party, what are ethical obligations? Let's say, do we say only the things which align with the hiring party, or just everything, the
Well, the
truth and
answer
nothing
is
but the
no.
truth?
Yeah, things which are as what Judge Crosswell said in the Curie Refer, you are there to render your opinion. So if your opinion is in line with the party who appointed you, then that's the benefit of the party who appointed you. If it's not, you're also duty bound to the court, and as an expert, an ethical obligation to also state your views as you think they are. If you're not favorable, then there are other options for the party who's appointed you and for the lawyer who's acting for the party who's appointed you.
Normally, if we are appointed, when we go through, we can express our opinion, and if it doesn't align, we may not be their expert witness of choice. Would that be the case?
No, so that would be close to forum shopping. When you are appointed, when you are approached to act as a witness, as an expert witness, then your duty is simply this: consider all the material provided to you, and then render your honest opinion. That is all the party appointing you is asking for, actually. They're not there they're not asking you to basically say what they want you to say. You are to say what you in your honest opinion think on the issues at hand.
Okay. What about reputational risks? If the case is controversial or high profile, will it impact on our professional reputation? And how do we navigate this?
Sorry, on the expert's reputation or on the doctor or hospital who's been sued?
I think the question refers to the experts' reputation.
Well, okay. So as an expert, you are there to maintain your professionalism at all times. So if you're there in court testifying, then if you carry your duty and remember that you're there to be unbiased and independent, then I don't think there is a problem with your reputation, is there? I don't think so.
Yeah. Okay. And what if the counsel challenges qualifications or expertise? And can they do this?
Yeah, they're entitled to. So what actually happens before a trial is the expert will not only provide his or her expert report, they will also attach to that they will also furnish to the court and all the other lawyers involved a copy of their latest curriculum vitae. So in your curriculum vitae, you will set out your education, your qualification, your training, and your experience. So that is the reason why when your first approach is very important, as I said in the webinar just now, you need to assess whether this is an area of medicine that you are qualified to render an opinion on. So we don't want a doctor practicing daily in area of medicine A to suddenly give an opinion on area of medicine B. And you ought to be forward enough from the outset to tell the person approaching you, no, this is not my field of medicine. And if you do that, you won't get caught up. Is I think only on the circumstances, in the circumstances where you're not really an expert in that area, but you take on the appointment anyway, and then you're running a risk of being, shown up at the trial.
You see, medicine, sometimes we are specialists in one field, but actually within that field, there's actually, as you say, like subspecialties, and we may not be total experts in that. If it comes, should we not avoid such scenarios?
Yeah. So the example I gave during my webinar is, I think, a good example. If you're an obstetrician, a gynecologist, but the area is actually regarding fetal medicine, which is a subspecialty, then say, maybe you want to approach a fetal medicine physician, and that might be the person more qualified to render his or her view.
Yeah, maybe that would be the safer way.
Yeah, I think it is. We have many instances where we approach experts and they say, oh, you're knocking on the wrong door, try a different door. Yeah.
What if new evidence emerges during the trial that contradicts one's previous testimony or report? Has that ever occurred?
What the law provides is that if new evidence comes to light, the expert is entitled to take that on board. And if the expert now says, oh, because of this new evidence, my opinion is somehow changed or altered, then he or she must tell the person appointing them immediately that, that day I was in court, I heard all this. I think in light of that evidence, my report needs to have an addendum, or I need to now explain why I've come to this. And then once you do that, then it can be taken on board at the trial itself. So the idea is it's not written in stone. You would have read the opposing party's expert report before you take the stand as an expert. But if you think there's something new that you want to take into consideration, then you need to tell the person who appointed you, especially if it changes your views. Sometimes new evidence doesn't change anything as far as the expert opinion is concerned. Sometimes it does, sometimes it doesn't. Yeah.
In the course of the testimony, we find that, we actually made an error in our analysis or testimony. Can we retract, or what can be done if that's the case?
Okay, so if I could just explain how a trial is conducted first, then that might give an idea to the person who posted this question. In a medical legal trial, the patient or the family members bringing the action will start the trial first. So usually it's the patient or representative of the patient, and then the expert, but that is usually the way it goes. And then the lawyers, in the lawyer's parlance, will say the plaintiff will close his case. That means the plaintiff's case is over. Then assuming there's only one person who sued, which is the doctor, then the doctor gives evidence, and then the expert for the doctor gives evidence. Now, you are now thinking that maybe whilst the expert for the plaintiff is giving evidence, you want to reconsider what you've written. Again, the same thing applies. If you want to reconsider, tell the person who appointed you immediately. You do not want to take the stand as an expert only to be told that you have written the facts wrongly in your report, or that your conclusion did not take into account these facts and things like that. That is highly embarrassing. So that is why we always advise potential experts to read the documents properly and to make sure that the facts they have extracted and put in their report is accurate. You really don't want to be caught out on the stand.
And in the question on Slido on the screen now, how best to respond when the other team tries to discredit our findings?
Your report or any findings or conclusion in your report would be based on the available evidence, would be based on the applicable medical literature, and would be based on your qualification, training, and experience. It is the job of the opposing counsel to test your opinion. So, in testing the opinion, you need to explain to the court, even if it's 50 times, even if you have to explain 50 times why you came to a particular finding, what are the facts you took into account, what are the medical evidence, medical literature you took into account, and why you came to a conclusion. Unfortunately, that is how a trial is done. They are there to test your opinion. If you have all these ingredients, I do not see why you are not able to stand by your own opinion. It is awkward. It is sometimes, what's the word for it? It is sometimes embarrassing, and if you have to say the same thing over and over again. But then I would say, if you have a judge who's listening to the proceedings, you would then say, okay, I said it just now, this is what I'm going to say, I've said it again, I'm saying it now again. That is how you would, I think, deal with that form of cross-examination.
The issue is medicine is not an exact science. There are often a lot of gray areas. It's not black and white. So when we evaluate something, I think lawyers and judges, I hope, would know this and take this into account. And how would you how would you comment on this on the basis of expert testimony? I mean, we experts, while we have some experience in the field, cannot say for certain in many scenarios because there's often some area of gray areas and uncertainty, in medicine.
I agree. So that is why, given the same set of facts, the plaintiff's expert may come to conclusion A, the defendant's expert may come to conclusion B. Then, after hearing opinion A and opinion B, the judge is then tasked with the responsibility of evaluating the evidence against what happened at the trial, against the documents that we put before the judge, and then come at the conclusion whether the evidence of expert A or the evidence of expert B is going to be accepted, subject to, of course, the Boleto test, which I explained just now at the webinar.
Okay. Are there cases where the expert testimony or report is disqualified by the court?
I'm not sure what disqualified mean. If the person asking means is not accepted, yes, because as with any trial, somebody has to win, somebody has to lose. So somebody's opinion has to be accepted, somebody's opinion is not accepted. That's the way a trial, a civil trial, including a medical legal trial, is run, and that's how it concludes.
Okay. I think we'll just take one more question about patient confidentiality. In cases where there might be a need for full disclosure, which might harm the patient or their reputation, are there limits in the court of law for?
Okay, sorry, Dr. Allen. I'm not sure I understand this question correctly. By the time a matter is in trial, the documents or the medical records of the patient is already part of the court papers. So the confidentiality, in the sense that I think the person asking the question is asking, is not a material issue any longer.
Yeah. So I think
because we know who is the patient, and we know that's the patient who is suing. And in the process of preparing for the trial, the patient, through his or her lawyers, would have given up the protection of confidentiality by proceeding with the trial, by disclosing his or her medical records for the court to look at in trying to come to a determination at the end of the trial.
Right. Okay. I think there are no more questions in Slido. I think we're it's been instructive evening. We don't want to take too much of your time,
No,
but
I'm happy
yeah,
to be here.
yeah. So I think I hope this will give some of us confidence to be expert witnesses. I mean,
Yes, please.
you know, I, I, we've been also sometimes approached, and sometimes we feel bad if we don't try to help our colleagues. But at
Well,
the same
help
time,
your colleagues if it's, as I
yeah,
said, apples are
mm,
apples and oranges. If
mm,
you are the person who's the appropriate expert, then by all means, step up and say,
yeah,
yes, I will help.
yeah,
If you're not, then please don't do so.
yeah.
Yeah.
Okay. So I think we'll take this to the close, and
Okay.
yeah, S- the
Okay. Thank you
attendance
very
link.
much, Alan.
Yeah, thank you very much for point, Mazura. And I think the
Pleasure,
doctors are
absolutely.
waiting for the CPD points.
Oh,
You
okay.
can, yeah, it's okay. This is
I
just
will
the
step out from
time.
the admin part of the
Yeah.
webinar.
Yeah.
Okay.
So for the medical doctors, you can go to dops.my/1111224, which is today's date, and the QR code takes you to that link as well. So this QR code is not to be scanned by the MMA scanner, no more. So this one is your normal QR code scanner to help you go to that link. So you go to the link in your browser, be it Google Chrome or Safari or whatever, and it will take you to a Google form. Just fill in your details to enable us to mark your attendance. We'll upload the attendance tomorrow. So all the attendees, you still have time until midnight tonight. Okay, midnight tonight, the carriage will change from a to back to a pumpkin, and then the form won't work anymore. So right now, it's still valid. So now, later on, we'll still host the video, and we don't use the form, but we will put a pin comment in the video for people who have viewing this from tomorrow onwards. So we'll tell you how to claim the CPD point for watching. Um, so thank you everyone for staying right till the end. I think we still have the same 30 plus live attendees, but there will be more. Usually we have a few hundred views, and it's been very instructive, and I think in a sense also quite inspiring for those who have been wavering or sitting on the fence whether or not to be an expert witness, because sometimes there are fears. We go there, we worry, we get grilled and so on. So and it's also time consuming. So but we do understand there's a need, and it's actually for the sake of the profession. If not helping each other, then who else is going to do that? Yeah.
Absolutely.
Yeah. So thank you once again, Pon Maizura.
My pleasure.
Lovely to have you on again, and
Yes.
we hope we'll have you on for future occasions.
Inshallah,
So
as they say.
yes,
Yeah.
thank you, and good night.
Good night,
And
everybody.
it's a holiday, and it's great
In
that everybody
Selangor.
could. Yeah, it's a slang or in slang or yes.
Yes.
All right. So good night, everybody,
Okay.
and
Thank you
have
then.
a great rest of the week ahead. All right.
Thank you, Dr. Aaron.